opening prayers so that we can start now?
Yes, Attorney.
Thank you.
Let us put ourselves in the holy presence of God. Sa ngalan sa Amahan, sa Anak, sa Espiritu Santo. Amen. Langit nung Amahan, daghan kayong salamat sa lain na usab nga higayon nga nagkapundok kami karong gabiuna. Daghang salamat sa madasigon kaayo kanunay nga kakugi ni Attorney Josephus Jimenez ug daghan kayong salamat sa mga presensya sa matag-usa ni ining gabiuna, labi na kang Dr. Jimenez ug kang Attorney Julias. Hinaot pa unta nga kanunay magmadasigon ang matag-usa kanamo sa among pagpadayon ni ining Visayas OFWs. Kini among gipangayo pinaagi sa ni Kristo among Ginoo. Amen. Sa ngalan sa Amahan, sa Anak, sa Espiritu Santo. Amen.
Mauna nga Attorney Gulyas, may hapon unya kani si Attorney Wagas og mga di ganina yaging bidisayon kay ako nang ingnan na ayaw mo pag in English og mga di mo para ang grasya sa Bisaya ay padala ayaw ipadala sa Amerika kay sige lang pangadig English sa Amerika raman ipadala ang grasya kay abis Ginoo og mga Amerikano ray nga di unang mga di gani bidini binisayon ginamo no kay University of Bisaya aguta.
Hello?
Yes. Nawala. Hello?
Clear naman ni Attorney.
Ha? Clear?
Klaro ra kay ka.
Okay. So today, ladies and gentlemen, we will discuss a very important part of labor law, and that is the law on recruitment. Recruitment is one of the most important pillar in labor administration in the Philippines today because you might not know it, there are 12 million Filipinos who are deployed in 200 countries all over the world. There is no country in the world without a Filipino. The Filipinos were the ones who constructed all the buildings, the highways, and the infrastructures in the Middle East. In the height of the construction boom in the 1970s, there are now presently more than 1 million Filipinos in one country alone, and that is the Kingdom of Saudi Arabia. I was assigned as a labor attaché, supervising all the other labor attachés because I was the undersecretary. I was in Kuwait, which is a very small country, but with 176,000 Filipinos. So today we are going to discuss the law and jurisprudence, the leading cases about labor migration, one of the emerging economic and social phenomenon of our times. And so, as you can see, I have prepared a module for all the 36 meetings. For the information of Attorney Gulyas, I have committed myself to 36 meetings, and I will serve my alma mater for free without anything. I don't expect anything in return because I finished my law in the Gulyas Law School in 1974 on top of my class as magna cum laude and class valedictorian. And for 4 years, I did not pay a single centavo to the university. I was a full university academic scholar. And so today, I give back what I have received. And I have prepared a complete curriculum, and for today, we will study the most important articles in Book 1 of the Labor Code. We will look at the Magna Carta for Overseas Contract Workers, which is Republic Act 8042, and the amendatory law, which is Republic Act 10022. We will discuss cases of illegal recruitment and illegal dismissal of OFWs, especially the en-banc decision in the case of Samir Overseas Employment versus Joy Cabeles, which is decided by the Supreme Court en-banc with the Associate Justice Marvic Leonen as ponente. As you all know, he is the chairman of the bar examination next year. So it is important that we scrutinize and look into the decisions written by Justice Mario Victor Leonen, a very famous professor of law in the University of the Philippines. And we will also look at the principle of lex contractus in conflict of laws and international law, which is a part of the law of the land by virtue of a declaration of basic policy of the state in Article 2 of the Philippine Constitution. The Philippines not only renounces war as an instrument of national policy, but also adopts the generally accepted principles of international law as part of the law of the land. So to start, ladies and gentlemen, we are now approaching the number 30. So for all of you who are going to take the bar, please take note. These 4 articles, these are the most important articles of Book 1. Please write this down. This article 13 is the definition of recruitment. It is important that all of you should memorize. I will give you a mnemonic device, very easy to memorize. What are the acts that constitute recruitment? And Article 34 and 38, these are enumerations. 34 is an enumeration of the Prohibited Act. Mala prohibita. What are the acts that are considered prohibited and are considered acts of illegal recruitment? And remember that since it is mala prohibita, you do not have to prove willful intent. And the accused cannot raise the defense of good faith. When a person is accused of illegal recruitment, all that the victim will prove, the prosecution will establish in court, is that the act has been committed. And these acts are enumerated in Article 34. And I will give you a mnemonic device how to memorize Article 34 as amended by Republic Act 8042 and 10022. Then Article 38 defines what is illegal recruitment in large scale, what is illegal recruitment committed by a syndicate, which constitutes a crime of economic sabotage. And the penalty would be life imprisonment and a fine ranging from 1 million to 2 million pesos for every count of illegal recruitment. Well, Article 40 is included because this is the article that allows the grant of alien employment permit to non-resident alien. And the leading case is very familiar to us because it involves General Milling Corporation versus Secretary of Labor Ruben Torres. General Milling because I remember the lawyer or General Milling was Attorney Joseph Badwell, one of our outstanding alumni. And this is the case where Tim Cohn, the coach of the basketball team of Alaska, because Alaska is owned by General Milling, and that is the only case involving Article 40. So why am I telling you about only 4 articles? Because most of the articles of book 1 of the Labor Code are already abrogated, repealed, or they are not important. What is strategic in reviewing for the bar, Director Jimenez, is you know what are the critical few versus the trivial many. This is the Pareto principle. Kayong mga you who are listening, no, all of you who are listening to me, you should know that not all the articles are important. In other words, just like anything that you see in the world, there are only very few things that are important, and that is called the critical few. And the rest are called the trivial many. When you use the Pareto principle, and my bar reviewer is using the Pareto principle, meaning only 20% of the total number of articles on the Labor Code are important. And if you keep attending my lecture, you will know what are these critical few articles. And these critical few articles includes these 4 articles for Book 1. So if you can just focus your attention on these 4 articles, you can read just the other articles in passing, but you have to spend more time on these 4 articles because these are the one that will give you the questions. No? So the first question that may be asked is this: is it the Philippine government's policy to promote overseas employment? In other words, are we pushing our people to work abroad? Is the government training and educating people only to work abroad? Because if you go to Kuala Lumpur, the Twin Towers were constructed by Filipino engineers. If you go to Taipei, the tower there were constructed by Filipino engineers. If you go to the Burj in Dubai, the tallest building in the whole world, who were the engineers? They were all Filipinos. So the question is, are we promoting overseas employment? The answer is no. The political answer is no, politically correct. Although the truth is, we are really pushing our people because there is no available jobs here. And if there are, they do not pay as much as the jobs abroad. That's why we are losing nurses, doctors, because our hospitals here cannot pay as much as the amount offered by medical institutions in New York, in New Jersey, in Texas, in San Francisco, in Canada. So the answer to this, if you are asked in the bar examination, you should cite the law and say, under Republic Act 10022, paragraph C, amending Republic Act 8042, the Migrant Workers Act, it is explicitly provided that overseas employment is not promoted as a means to sustain economic growth, but it is a choice. It is a choice, meaning it is the Filipino workers who will choose whether to go or not to go. So, as a matter of law, we do not encourage, we do not push our people. But in reality, the socio-economic conditions of the country make it imperative for the Filipino human capital
tanawa ko no.
to seek employment abroad.
Sige na ko.
Unsa na to? Director Jimenez, can you hear me?
Yes, USEC. Very clear.
Ikaw jud ang akong buhaton diha nga kana kanang ikaw mo'y class bidel, ikaw mo'y mo coordinator nako, basta mo hunong gani. If the Wi-Fi is problematic, you just give me a sign, no? Okay ba, Director? Okay, Director?
Okay, USEC. No problem.
Anyway, I am older than you. And you consider me as your older brother.
Yes.
Can you read that, Director? These are the basic principles enunciated in the Migrant Workers Act. No? Can you read that?
Yes.
So there is a mnemonic device, spade pops. Okay.
Spade pops. Yes.
Okay. So in the Constitution of the Philippines, there is a declaration of policy and principles, the fundamental principles and basic policies. Here, if you remember, ladies and gentlemen, Attorney Wagas, if you were already born when Flor Contemplation was convicted of murder in Singapore, in the 1990s, during the time of President Fidel B. Ramos, there was a household helper from Batangas by the name of Flor Contemplation. And that domestic helper, Director, visited her friend, ang comadre niya, si Delia Maga. Delia Maga was another Filipina also from Batangas. She was taking care of a baby, the daughter of a Singaporean couple. And while they were talking, because ang sabi ni itong si Flor Contemplation, I'm going to Delia Maga because he is going home to the Philippines. I'll send money to my family. Instead of paying the Western Union, I'll give her the money, So they were talking. While they were talking, the baby drowned. The baby drowned in the swimming pool. See? And so the father was enraged and killed Delia Maga. But the most convenient alibi and scapegoat was Flor Contemplation, because she was there and she was the one accused of killing Delia Maga. And to make the story short, Flor Contemplation was convicted by a Singaporean court because of the death of a Singaporean baby, and Filipina is the victim and Filipina is the accused. The judge is a Singaporean, the defense counsel is a Singaporean, the prosecutor is a Singaporean. She was convicted and sentenced to die. And Flor Contemplation died. Director, can you hear that music?
Yes, hello, attorney. Na I think dahil mga bata. Music. Yes.
Napasukan tayo ng masamang espiritu. Okay, I will continue, Director. Ladies and gentlemen.
Sige.
Okay. So, because of that, because of the death of Flor Contemplation, nasuko ang mga Pilipino, why was the Philippine government not able to use diplomatic means to prevent the the execution of law contemplation. And so the Secretary of Labor was asked to resign. And the Secretary of Foreign Affairs also was asked to resign. And that they were very good officials. Huh? The first woman to become Labor Secretary, Nieves Confessor. And Triple R. When you say Triple R, that is Roberto R. Romulo, the son of Carlos P. Romulo. He was the Department of Foreign Affairs Secretary. And both of them were kicked out by Fidel B. Ramos, president, just to appease the Filipino people. And not only that, Fidel B. Ramos certified as urgent an amendment to the Labor Code, which became Republic Act 8042. You know the story now. You know, if you are a good professor, you should tell the history so that the students will know philosophy, the legal philosophy, and they will understand, ganito pala yung balaod, mauna yung ana, no? So, ngayon, ito, these are all the policy. Number one is, when you go abroad, your number one weapon is your skills. Because the unskilled people are the ones that are most vulnerable. 90% of the problems involve domestic helpers because they are the most vulnerable. They are unskilled. Unlike the factory worker, the restaurant, hotel, the embassy can go and visit them. But if they are working in the household, in the private domain of the Arabs, the Philippine embassy cannot just enter into this private domain. So they are the most difficult to protect. So now the Philippines, as a matter of policy, is making sure that we should send skilled workers. Now, as a labor attaché, I recommended that we stop sending domestic helpers because they are overqualified, they are college graduate, and yet they are being raped, they are being maltreated, subjected to degradation, ridiculed, and their dignity and human rights are trampled upon in a foreign land. So skills is most important. Number two is protection to OFW. And this law is full of protection, including legal counsel. Whether you are a documented Filipino or not, you are entitled to be given a lawyer by the Philippine Embassy. And the Philippine Embassy will pay for the lawyers in the foreign land. And they have access to the courts, to our judicial system, which is without pay. And their cases are given priority in terms of early resolution and in terms of legal assistance. The dignity of the human person is not negotiable. That's why today we do not send any workers to any country without the ambassador certifying that the host country, kayo ha, mga nakikinig sa ako, you should always put it down in writing na as of today, because of the provision of 10022, amending 8042, we cannot deploy any Filipino to any country in the whole world without one very important document. What is that document? It is the certification by our ambassador submitted to the Secretary of Foreign Affairs, then to Malacanang. What is the content of the certification? It will state that as the official representative of the Republic of the Philippines in that host country, he certifies that the government of that host country has all the safety nets, all the legal protection. In other words, In their legal system, there is a law on 8-hour labor law. There is a law on overtime. There is a law on health, safety, and welfare. There is a law on security of tenure. There are laws about the right to self-organization, the right to collective bargaining. All the laws of which we are all signatory to the International Labor Convention, because these are part of the law of the land by virtue of Article 2 of our Constitution, that we adopt the generally accepted principle of international law as part of the law of the land. Director, can you hear me?
Yes,
Yes, Attorney.
USEC. Actually, I'm taking notes.
Very good. So, the next principle is equality of men and women. You know that in the POAA board, as well as in the UA board, there is a representative. There are 2 representatives of OFW. One must be a woman, because the women are given much importance because of our policy of respect for women. We are a signatory to the CEDAW. Ano yung CEDAW? Convention for the Elimination of Discrimination Against Women. Tandaan nyo yan. Kaya sa mga labor code natin, sa mga decision natin, kana mga discrimination against women, you can use in answering the bar examination question, not just the provision of the labor code, but also the international law, one of which is the CEDAW, CEDAW, Convention for the Elimination of All Discriminations Against Women. No? Alam ni Attorney Wagas yan, kasi bilang babae ay napakahalaga sa atin ang mga babae. Dito sa Pilipinas, ang biktima ng discrimination ay mga lalaki. Nabaliktad na ang discrimination dito. Hindi na ang babae dito ang pinapaboran ng lahat ng batas. Ang mga lalaki ang kawawa. We are the endangered species.
You're very correct, USEC.
We are the endangered species, no? So sometimes we should also organize, no? To organize the men against the oppression by the women, no? Kailangang mag-join tayo sa party list na uhaw. Alam mo ba yung uhaw, Director? Ang meaning ng uhaw is union of husbands afraid of wife. Biro lang yan, kasi hindi nakinig yung misis ko, no? Okay. Participation of Filipino migrant workers in decision making. That's why in the board, governing board of POAA, governing board of UA, there are 2 participations from the women. Even in the Social Security Commission, women are represented and men, and even OFWs. So, number 7, again, we are not promoting overseas employment, but it's a matter of choice. Partnership between NGOs and the government. Director, just like the DepEd, you have partners, the NGO, like there is an association, a very progressive association of teachers, like the ACT, no? The ACT, no? The Alliance of Concerned Teacher, which is a party list. So, we cannot consider them as our enemy because they are non-government organization. They are people's organization. So, in the overseas employment, there are many progressive, like the Migrante and others. We consider them as our allies, partners, because they also help in the protection of the Filipino migrant workers. No? Okay, free government services for migrant workers, supposedly free. pero magbayad man sa UWA, no? Magbayad lahat ng mga membro, magbayad kayo. Pag namatay kayo, entitled ka ng 300,000 pesos na death benefits from UWA. Aside from the fact that under the amendatory law of 10022, all employers, remember this, all employers, foreign employers, when you get a Filipino, before the labor attaché will sign your contract, you have to procure a life and accident insurance. So today, any kinds of death, no, and accident are covered by death benefits. That is why our seafarers, the spouses usually get $120,000 US. Take note, $120,000 US. Not only death, permanent total disability. When a seafarer suffers from a permanent and total disability, he is covered by insurance. And this insurance is a necessary component to the contract. The contract will not be signed by POAA unless there is a valid insurance policy coterminous with the term of the contract. So if your contract is 2 years, you have to be insured 2 years. And what is important here, ladies, you should remember, gentlemen, the premium should not be, the burden of paying should not be shifted to the worker, the OFW. It should be shouldered by the employer. Now, if there is a violation, if there is a deduction of salary to answer for the premium, that is considered as one of the prohibited act under Article 34 of the Labor Code as amended by 8042 and 10022. That is a malum prohibitum, and that constitutes an illegal recruitment. And if the victims are 3 or more, it becomes a large scale, and therefore the penalty in the criminal case is life imprisonment and a fine. Not or, ha? Huwag niyo gamitin ng or, basta illegal recruitment and yun na, imprisonment and fine. Of course, they cannot afford. I don't know. The law is silent. If there is a subsidiary penalty adding to the life sentence, it's already a life sentence. And then if they cannot pay, no, are they going to serve in prison commensurate with the amount of fine? Because it's very difficult to collect from people who are convicted of illegal recruitment. So with that, ladies and gentlemen, now I am giving you this. You take picture, if you have pictures. Director, is this clear to your screen?
Yes, USEC.
You can do not copy, you just take picture because it will take time to copy. No? You can take picture because this is Article 13, paragraph B. And any person, whether natural or juridical, who commits any of this act is deemed to be engaged in illegal recruitment if he is not licensed. Take note, ha? Kamo, naminaw mo. Mr. Carion, na baka diha? Mr. Carion?
Na attorney present.
Permig, you can present. Onya, kani, basta makita ninyo ng any act, kahit referral lang, nag-refer ka lang sa usa ka tao, wa man kakakwarta because dito nakalagay whether for profit or not. the receipt of a money is not a necessary element to consummate the crime of illegal recruitment. So it is not a valid defense for an accused to say, yes, I did the act, but I did not receive money. I was just helping. Kahit ikaw, Director, kahit pare ka pa, nag-refer ka, na pare taga Bohol, taga Inabanga, gi-refer niya itong Osaka, taga Dimyaw, Bohol nga, gusto mo trabaho pagka domestic helper, yang nisulat pa ang pare, isulatan dito ang recruiter nga, kani pasudla ang taon yung trabaho kay parting pobriha. Ang pare noon pwede magkasuhan. Ano? Because he is the one referring og palpak tong transaksyon na dili jud maka-abroad og na-abroad man na subjected to contract substitution, katong pare nga nitabang usa po to sa accused. Because maingon pare, wa mo ko mangwarta na. Kanang pangwarta is not a necessary element. You don't have to prove it because it's not an element. No? Yung, in good faith man ko, sir, in good faith. Good faith is not a defense in imalum prohibitum. Wala man ko intention nga makadaot. Willful intention is not an element. All we have to do is that the act was committed. Are you following me, ladies and gentlemen?
Yes,
Yes,
attorney.
attorney.
Kanatanan ako ng ibuhat o pan, ni Monik, no? May mga masag kani, usbo ninyong ni Monik. Kani sa kuan na ni, sa katong ni Monik kanina, pwede niyong balihon, ni mga niyong chapter caps. No? Pero sa Prohibited Act, this is committed even if you have a license. Take note, what is the difference between Article 13 and Article 34? Article 13 can be committed by anybody with or without a license. Pag may license ka sa Article 13, wala kang sala. So kailangang unlicensed ka para ka makakumit sa Article 13. Pero dito sa Article 34, even if you have a license, if you commit any of this act, you are guilty of illegal dismissal. Is that clear to you?
Yes, attorney.
Yes, attorney.
Yes, yes, USEC.
Bugada naman na si Atty. Wagas. Kanang uban.
Yes, USEC.
Kapasar na ko na.
Present.
Ang butahain na to si Atty. Jared. Pauli na.
Napa, attorney.
May napalikturo na to na si Atty. Jared o si Atty. Wagas. Palikturo na to na. Kay abogado na guna kabugada niya. Gulyas pa na niya ato ginapaminawan o mo lecture na. No? Palikturo na to na. Si Atty. Jared Gulyas. Muna yung ngayon mag-congressman.
Bitaw, attorney.
Bitaw, og mawa na dahil si Congressman Edigol, mo pahuhay na siya. Siya na yung kontra ni Gwendolyn. Para gobernador na siya na si Edigol niya. Kani si Jared mo na itong pahimuong congressman sa 1st District.
Aga kuyog-kuyog na siya, USEC. Actually, I met Attorney Jared during a meeting with congressmen. So, he was with Congressman Golias.
Okay, guwapo siya na.
Siya mo'y kuyog-kuyog ni Sir Eddie.
Sakto, sir.
Dugo man na Francisco. Kaya ang inahan ni Sir JBJ, Francisco man to. Mga ngilingig siya ng abogado mga Francisco. Kana si Kuan, si Samsam, dugo po nagsilma, tagaming Glanilla na. No? Okay, padayon ta ha. Kaning ma-memorize ninyo ni Monique Device, Director, kaning so big, so big a wife. Memorize mo na. Kamo karyon. Dan, makuha
Yes,
na
yes.
ninyo.
Yes, attorney.
So big a wife. Number 1, contract substitution. I don't have to explain that. You know, when there is a contract of employment approved by POAA, and then you alter, you change the name, you change the position, you change the salary, whatever term and condition, instead of 2 years, you change to 1 year. As long as you substitute the contract, that is already a contract substitution. No? Mga obstruction of the visitorial power of the Secretary of Labor. You know that the Secretary of Labor has 3 visitorial powers. O ako, examiner, ako ginapangutanon. What are the 3 visitorial powers of the Secretary of Labor? Ang answer niyan, the first visitorial power of the Secretary of Labor is under Book 1. Book 1 of the Labor Code, which is the Secretary of Labor can go to any establishment of the recruitment agency in order to verify whether the recruitment agency is compliant with the provision of the law. So anybody who will obstruct the process of recruitment of visitorial power shall be guilty of the Prohibited Act, which is a malum prohibitum, and that act, and that is in Article 37. Take note, Article 37 of the Labor Code of the Philippines. What is the second visitorial power of the Secretary of Labor? In Article 128 of Book 3 of the Labor Code, the Secretary of Labor or any of his duly authorized representative can go to any establishment for the purpose of verifying compliance with general labor standards, including wages, hours of work, benefits, overtime, 13-month pay, and night differential. They don't, the Secretary of Labor or any of his representatives do not need any search warrant from the court. On their own authority, they can go there at any time, even at night. At night, when there is an operation, like San Miguel is operating at night, bottling the beer. As long as there is operation, the DOLE representative inspector can go there and examine the payroll, interview the workers, take copies of documents, take pictures of the environment, look at whether there is unsafe and conditions that would expose the workers to hazards to their health, like obnoxious chemicals, like highly inflammable materials without any safety gadgets. All of these are subject to the second visitorial power of the Secretary. The third one, if you remember, the Secretary of Labor in Book 5 can also inspect the books of accounts of the union, but not automatic. There must be at least 20% of the union membership who will petition. Itong first and second visitorial powers are automatic. They do not need any complaint. They do not need any report. On their own, motu proprio, the DOLE can go to the establishment. But on the third one, in Book 5, for the Secretary of Labor to have the authority to go and inspect the books of the unions to determine whether the officials of the union are not malversing union funds. This is to protect the workers from their own unions. The secretary has access, and there's no need for a search warrant to do that. So I mention that because in this provision now before you, obstructing the labor secretary's inspection authority is an act of illegal recruitment insofar as recruitment agencies are concerned. Number 3, you might wonder why officers of recruitment agencies are not allowed to be officers of travel agency. The answer is very simple. If you own a travel agency and a recruitment agency anytime, there is a strong tendency that even without a job order, even without a clear work waiting, you will deploy the worker because you are in a hurry to get the placement fee. You will deploy them as tourists. And so when they arrive and they work, while they have a tourist visa, they will be arrested for violation of the immigration laws of the host government. Can you imagine that? So all these laws, ladies and gentlemen, the bottom line of this is very simple: protection to labor. Lahat ng sinasabi kong batas from Book 1 to Book 7, there's only one bottom line, common denominator: protection to labor. In Book 1, the OFWs are protected from illegal recruiters. They are protected from corrupt officials of government. They are protected from their foreign employers. And the protection is exercised through the laws that the Congress have passed, in the exercise of police power, and in the pursuit of social justice. So, ang dili nyo kalimutan, 3 things: protection to labor, police power, and social justice. The reason why Republic Act 8042 was passed and 10022 was the amendment was also passed is in the pursuit of social justice, which was defined in Kalalang versus Williams, not as atomism or communism. It is only humanizing the laws, and it is equalizing the forces in society so that justice in its most secular signification may at least be approximated pursuant to the time-honored principle of salus populi suprema est lex. So that is the purpose of social justice. What is the anchor? What is the means of achieving the purpose? Police power through legislation, adjudication, and enforcement of laws. And why is the state doing this? Because of protection to labor. Under Article 13, Section 3, I always tell you to memorize: the state shall afford full protection to labor, local or overseas, organized or unorganized, and shall guarantee labor with all the rights to living wage, the right to humane conditions of work, the right to a just share in the fruits of production, the right to self-organization, collective bargaining, peaceful concerted action, including the right to strike in accordance with law. Can you write as fast as I am talking? Because alam nyo, kayo, bisag kahit gaano kayo ka-bright, o mahina kayong sumulat, mahina pa kayong mag-isip, maubusan kayo ng oras, di mo kapasar. Kailangan sa taga mga Bisayan yan, taga UB, quick thinking, quick understanding, quick comprehension, then quick writing. Yung penmanship ninyo must be very, very nice, impeccable penmanship, readable, and graceful language, the language of a lawyer, with grace, but with firmness, with strength, but graceful. Diba? Okay. Next is inducing a worker who is already employed to offer him another job. Ito ganito yan, Director. Kung merong si Mr. X employed na sa Dubai, meron siyang kaibigan si Mr. Y. Pag Biyernes, day off man ang Biyernes doon, sa Sunday may trabaho man. Na mga Muslim area, basta Friday day off. Okay, nag-day off yung dalawa, si X and si Y. Sabi ni X, oh Y, where are you working? Oh, I'm working in a factory. How much are you receiving? Tapos sabihin niya magkano. That is a very low salary. You know, we have vacancy in our factory. I was asked by my employer to look for another Filipino. Pero ito si Y, he is trying to entice him to transfer to his factory. Mr. Y is already committed to a contract he signed before the POA. And now he is bringing him to another employer. That is an act of illegal recruitment because Mr. X is not a licensed entity to recruit. So Mr. X can also be guilty of illegal recruitment because he is inducing a worker who is already employed and offer him another job. Are you following me, ladies and gentlemen?
No. Oh, is
Yes,
that
yes,
possible,
attorney.
USEC?
Oh, that's possible. It's not just possible, it is the provision of the law. When you induce another worker to transfer, even if you're in good faith, yan, ang laging depensa niyan, Director, I'm in
Yeah.
good faith, I'm trying to help, I did not receive
Yeah, I heard
money.
so many.
Oh, that is wrong and that is punishable by law. Di man na sila mabasa ng labor code, malinaw ra ng gisulti sa labor code. Pero ako ra gibuhat og libro nga. Gibuhat na kog easy to understand. Kung kana nga ikaw busy ka kay trabaho nimo nya. Lisod po ko yung basahon ng libro. Kanang ang trabaho sa author, ang trabaho sa mga professor is to make it easy. Di ba?
Yes.
If you are a teacher and you make it difficult, you are not a teacher. You are a terrorist.
Correct.
You are a terrorist because pagdating sa classroom, pa-recite ka agad. Pa-recite ka agad, wa pa gani ka mag-lecture na ma-recite, gyapon ka, pa-recite ka. Ako di ko pa-recite. Pa-recite lang ko once a month lang. Pero medyo kong lecture kay kanang mga tao ni bayad ko nag-tuition para maka-cut-on mo niya, nig-abot imo nang i-terrorize para pa-recite. Makalumang paraan na yan. Nung araw sa Goliath Law School, may professor kaming ganun eh. Pag hindi ka makasagot, magtayo ka hanggang matapos yung 3 hours. No? That is cruel and inhuman punishment. No? Giwilgahan ko to na mo. Giwilgahan to na mo. Pero niingon man si Ikuan, niingon man si Dean, yung Dean na mo, si Matoy Sino. And sa ayaw ninyo nagwilgahe kay malakas kayo na sa mga gulyas. Amakan pa kaning UB, BI pa ni, Bisayan Institute, ni ano na din ni, kuyog taon na ni Don Vicente. Dilegi na matangtang din ni. Kamu no matangtang. So, nibalik na lang mi. Balik na lang mi kay. Pero may maming kasapaan, basta di mi ka-recite. Ang among filosofiya, maubitaw ng eskwela ta para tudluan ta unya pangasabaan man yung tagdita kay bao, no? Pero karon nga ako
USEC, kanang sigig pusil kada.
Pusil kanang mga
pusilon dayo.
Kanang mga professor nga sigig pusil, wa na maka-prepare sa iyang leksyon kasi kung naka-prepare siya, it is his duty kana naaman si Dinwagas. Sultihe ko na ni Dinwagas kanang mga professor ninyo diya nga
Yes,
at least 80% mag-lecture mo. 20% lang mo magpa-recite. Di kay araw-araw pagdating sa magbalasa dahil class record, class card, unya pusilon dayon. Kalo yan ang mga working student ba na niya wa pag yung kabasag libro, unya pa-recite na ma-discourage na lang noon. No?
Mao na sa un. USEC nga, pa eskwela nagbupagay paglingkod. matawgan na imong nga no niya. May 20 ka kaso basahon. O Jesus, matunong pa gyud ang wa mabasa.
Mao na nga, Director, ako, I impose it upon myself as a professor. Kayo din wagas, you require your professor na ilagay nila sa sa PowerPoint yung lahat ng leksyon nila. Kung wala silang time mag-PowerPoint, yung mga staff nimo sa Dean's Office, kanang mga working student, pabuhatan ng mga PowerPoint, na mauni election niya dito ha, professor, kay amo na ning gibuhat para nimo. Wala jud kay
Parahan.
wala jud kay reason. Tinuo mo na. Ito, seryoso ba ako, Dean? Seryoso ko na, if you want to improve the quality of teaching in Gulyas Law School, the first thing na i-hammer na to, kanang mga professor. Kay ang professor gani, how can you produce good students if your professor are lazy people? Even if you are the brightest professor, if you are lazy, ang maestro, director, na magyukas DepEd, ang una yung quality sa maestro, kugihan.
Correct.
Akong inahan, kadlawon pa gani, manggunting nagkalendaryo, magbuhat to siya o ka ng mga teaching aid. No? Parting kugihan na. Mo na nga dito kumuliwat niya. Kugihan yun. Kinanglan nga, teachers must be hardworking. Mga professor, kahit professor ka, abogado ka, tapulan ka, dili mahimo na. Okay, padayon. Next. Giving false information. Na ba nga, when you apply for a license as a recruiter, pangutanon maka, di maka mangitag 5 million, nganong naman kay 5 million sa bangko nga, domestic helper man kagikan ka sa Dubai niyan, domestic helper ka, niya ma-apply ka, magbuhat ka dinhi. O kana dai sila gihimo ng dami sa mga Arabo, kanang mga mahitsura nga mga maid gipakaslan kay 4 man asawa pwede nila pakaslan tong isa nya nigpangutana res POA, where did you get the money? You make a false representation because you are claiming to be the owner of the agency when you are just a dummy by a third person, a foreigner who is not qualified to be owning a recruitment agency. That by itself, misrepresentation, that by itself is an act of illegal recruitment. And that is malum prohibitum. Good faith is not a defense. Kita mo? Ayang accepting or charging excessive fees. Na mangutana, sir, pila man gyud ay ang ayan na fee? Very simple. If your salary as an engineer is equivalent to 50,000 pesos, your placement fee is equivalent to 1 month salary. That is the maximum. The recruitment agency cannot demand higher than that amount. So any amount higher than the 1 month salary, in fact, kung sundin yun na ito ang balaod, they are not supposed to collect until the day the employee has started working. Pero maingom sa mga agencies, saan pa na mo na pangulikta o nagtrabaho na di na ginambayad, na amo na yung siguro hundaan. No? So, sige lang. Ipiyongon lang na itong mata na ito anang balaura. Pero ayaw dyan mo pangpangayo og higher than what is allowed by law. Number 7, there is a job applicant who paid already the placement fee and he submitted his passport to the recruitment agency for purposes of obtaining a visa. So, Director, if you are the recruitment agency owner, I am the applicant, I will submit my documents to you, my clearances, so that when you go to the embassy of Saudi Arabia, you can have my passport stamp working visa. Now, here comes an agency who does not have any job order, and yet he received money from the job applicant. So he keeps the passport in the office. 1 year has lapsed and the applicant has not yet been deployed. So the applicant says, sir, can you just return my passport because I'm going to apply with other agency? And then he will answer, I'll not return unless you pay me a big amount because I have already spent money going to the embassy to get a visa for you. So withholding that document, including the passport, is by itself a crime of illegal recruitment. That is a prohibited act. So kayo, mag-answer kayo sa bar, I always repeat my admonition, my reminder to you is this. In all your answer, you must cite a law. So you should start your answer with, according to the provisions of Republic Act 8042, as amended by Republic Act 10022. Alam nyo, sa examiner, pag ganun ang start ng answer, wala na. Nakahir na ang kasing-kasing sa examiner. Kasi pag magpasagad mo sultig yes or no, niya wala mo'y according, you do not have a basis of your answer. Your answer is only your opinion. And the Supreme Court is not interested in your opinion. Correct?
Correct, attorney.
Yes,
Remember
correct.
Remember that you are applying to become a lawyer. So if you are applying to become a lawyer, you should prove to me that you know the law. So how do you prove to me that you know the law? All your answers must have a law. Yun, sir. Wa may kasiguro Republic Act ba to? Unsa to? Ingna lang na well settled in the principle of law. Or as decided by the Supreme Court in a long line of decisions, mo gina-start sa answer ninyo. O kamo, isa-isa mo, tawagon mo. Will you promise to me and to yourself under oath? Ikaw, Christine Kalumba, will you promise that all your answer will start with according to? Mamam tubab, no? Tingay gway tao. Kani si Kwan, di ako na sa listahan diri. Si Eupimio Catalan. Oh, Mr. Catalan, are you here? Wag yung tubag. Si Proilan Kunsad. Proilan Kunsad. Ha? I-unmute ba ninyo inyong mic niya, mutubag mo? Kanang Proilan. Ikaw ni Proilan? Or si
yes, attorney.
Oh. Ang akong itugo ni mo, Proilan, kamkuha ang yung kagbar, ang sagot ni mo, pag ingon ni mo, yes, ang sunod yun na according to the provision of Republic Act 8042, as amended by Republic Act 10022, doon pa lang sa salita mo na yan, ma-impress na examiner. Dabutangig kama ang answer ni mo kasi para makaginhawa po na mo basa ba. Kana bang kama ba, Direktor, gibuhat ng kama para makaginhawa ang mabasa.
Yes.
Ang mamatay niya ng basa ni mo. Basa sa imong sinulat, mamatay kay wa man kay kama. No? Kani akong gitudlo ninyong taktika. Useful kay ni. Kay wa pa'y professor mosulti ninyo nga sagot ninyo gani. Tulo ra gyud ka importantang part sa inyong answer. First is the law. That is the major premise. The second is the facts. That is the minor premise. And then your conclusion. So pag ang question is, is Mr. X guilty of any prohibited act? Yan ang answer, ang question. Ang sagot, yes, Mr. X is guilty. Period. Tapos, lagay, according to the provision of Republic Act 8042, as amended by Republic Act 10022, giving false information or misrepresentation in securing license or authority is a malum prohibitum. Period. That is the law. Ang sunod na part. In the case at bar, it is clear as shown by substantial evidence that Mr. X gave false information in the application for license. Period. Therefore, the examinee submits that he is guilty of one prohibited act under the law. So, nakuha nyo ako, may tatlong part ang answer nyo. The first part, answer yes or no. Then yung law, nandoon ang law. Ang facts, nakuha nyo. Then conclusion.
Conclusion.
Ayaw
Law,
na
fact, and conclusion.
ayaw na dugay-dugayan yung answer nga liko-liko ba niya. Wa pag yun ka mutubag, pangutana kag is he guilty or not? Sagutin mo. Yes or no? Di kayo mo pa kanang imong answer taas kaya mo gisulat niya wa jud ka makaigo. No? Pareho na og manguyab mo niya, di gyud mo kasulti, sige lang pasumbingay. Kinahanglan jud diretsohon jud ninyo ang tuyo ninyo. Kay nangutana man ang examiner, kay ba nagbalaod ni buangan ni, no? Kanira bang agi niya, lisod kayo. Your penmanship is hazardous to my health and your English constitutes unlawful aggression. So, ang answer, ang content, there is no law. Mayroon na examiner, where is the law? Then, walang facts. Ang conclusion, hindi malinaw ang conclusion niya. Now you realize, why people flunk in the bar? Simple lang. If you just follow my principle, kamo, karong gabi na, pila mo kabo? 33 mo? Palagay ko, mga 32 ninyo makapasar yun. Nalayo sa di kapasar kay maminaw.
Bugado naman daan.
Bugado na di na mo kuha. No? Bitaw, tinoon na, basta musunod lang mo sa akong tambag ninyo. No? Ayaw mo pag-absent ani, kay libre ko ni wani bayad. No, na nihatag ninyo, di pagyan mo kuan, di pagyan mo honor. No? Okay? So, all of you will promise to me influencing any employer not to employ any worker who has not applied. Yung bang exclusive? Pag ang isang examiner, isang recruiter mingon, ayaw magkuhag laing Pilipino, ari ragyod na ako, exclusive. Di na mahimong exclusive, that is a prohibited act. No? At saka yung, that is listed there as number 8. Number 9 is failure to submit reports. Alam mo yung mga agency kasi, they are supposed to render reports. Kasi police power, Visitorial power, ang gobyerno lagi talagang nagtatanong, are you complying? Are you complying? How will they know if you are complying or not if you do not make a report? Diba? Kayo sa DepEd, daghamang report, mga principal, submit mo report. Kamo
Yes.
mga division superintendent, report mo. O district supervisor, mag-report mo. Na may report, na may template. Hindi mo report. Report is an instrument of enforcement because how can we report to the President or to Congress? Paano si Ma'am Liling Briones ba mo report dito? Iyan na integrate lahat ng regions, no? na region di gyud mo report, ulahi kay mo report nig performance appraisal ninyo. Ako kontra kay nako nang kanang ma-delay ba? Ako, director, usad yun na sa akong gipangita ako mga subordinate ka nang mo-delay may mga. Ako as a regional director, kung regional director ka, I promise my boss to report on Monday. So your report must be here on on Thursday because on Friday I have to review. Then I prepare my report on Monday. If you cannot deliver on time, you are also making me fail in my promise to my superior. So when I evaluate your performance, kahit gaano ka pa kagwapo, gaano ka ka-bright, maliit yung performance nako. Di ba tinuod na, Director?
Tinuod. Yes. Ako, particular kay ko ana, USEC, even kanang late maabot.
Kanagong late, maubitang giingan lang kanang mamatay ka, may mga delete, Juan de la Cruz. Kanang mga perming malate, hapit na mamatay. Kay, kanang gitawag ba, Director, og deadline. Deadline. Sabot ang deadline. Pag hindi ka makaabot sa line, sa takdang panahon, dead ka na.
Dead.
Di ba? May meaning deadline, no? Okay. Engaging in recruitment of jobs harmful to public health or morality. Itong number 10 ha. Yung mga agency nang re-recruit ng mga dancer o niya buhatong prostitute. Tanawa na harmful to public health or morality. Daghan man na sa Japan sa una. Na daghan kayo nga Pilipina mauna ang tanaw sa mga Hapon sa atong mga Pilipina marag na mo-lockdown sila nga kaning Pilipina mababang klaseng pagkatao kasi moadto sa Japan walay laing punan mo apply singer unya di man ka mamukanta may lang mohawak og microphone unya di man mo kanta. Mauna nga, gidili gina, ni Ana na sa labor code, no? Allowing a non-Filipino citizen to head or manage a licensed agency. So kung palingkoro na imong banang Arabo, kadi siya magtinuod nga tag-iya, ikaw medra man ka, gibuhat kang front, pareho ragon na sa mga kuan, sa mga beach resort sa kuan sa Bohol o sa Cebu na ang tag-iya hapon pero ang di man makapalit og yuta kanang mga ilang pangasawahon ng mga babaeng Pilipina buhatong front. Ganon lang yun. Para paupuin mo yung foreigner to manage a recruitment agency, that itself is a prohibited act. Number 2, added by 8042, is failing to deploy a worker without valid reason. Tinanggap mo yung placement fee, hindi mo dineploy, kasuhan ka. So kung kamo naminaw na ko, doon na may mga parente, nagbayad na, sulati, buhatig demand, padadig demand ng worker, ngayon na according to the provision of Republic Act 8014, mukurog din ang mga recruiter basta butangan ni mo according. According to Republic Act 8042, amending the Labor Code, Article 34, you have failed to deploy the worker without a valid reason. You are hereby ordered to return the placement fee within 5 days from receipt of this letter. Failing in which we will institute criminal charges against you, administrative charge to cancel your license, and criminal charge for possible imprisonment under the labor code. Tinan mo, isa uli din ng pera. Basta, inunan nyo, ana. You don't have to be a lawyer. Basta mag-cite na mag-according. Napaka-powerful kayo ng word na according, Doktor, Director. Basta gamitan mo according to. Mahadlok mo ng mga tao, basta na according to.
Sabi na inon na according to USEC Josephus Jimenez, USEC.
Nga kay na
Sa
may
labor.
mga kaila, may mga kinsa man kuna, pero batas na gana, balao dengan na imong isite. Adto na gid
Labor,
sila preso.
labor, basta labor. Why wa kaila nimo USEC?
Magani mo like, magani mo subscribe sa akong kuan, sa akong YouTube. Oh. Sige lang, padayon lang ta. Failing to reimburse. Kana bang number 3, Director, kanang wa ni mo mapadala ang tao, gidawat mo ang pera, you have to return. Kasi pag dalawa ang double ang count 2 counts of illegal recruitment. First is failing to deploy. Second is failing to return. Failing to reimburse the expenses. Kita mo, i-reimburse mo yung expenses niya. Gumastos niya from Jensen pumunta sa Manila. Tapos, ang daming gastos. Ibalik mo sa kanya yung mga gastos niya because failing to reimburse will constitute a prohibited act. Na ito pang dinagdag ng 10022. Alam mo yung 10022? Kung ang 8042 ay nagawa siyon because of floor contemplation, ito namang 10022 was enacted because of Sara Balabagan. Who is Sara Balabagan? You know him? You know her? She was a very young, beautiful Muslim girl who was a minor, but the passport was tampered to make her appear as 23 years old because you cannot be recruited a domestic helper if you are not at least 23 years old. Hindi 18, hindi 21. 23 basta domestic helper. Ngayon, ito si Sara Balabagan, pinalsipay yung kanyang passport niya. Wapam dito si Sara. Why? Batang-bata. Pagdating doon, she was raped by the Arab employer. So, because Sarah is a Muslim and human dignity is very important, she used the knife, the kitchen knife, to stab the attacker and she killed. And because of that, Sarah was sentenced to die. You know who saved Sarah Balabagan? It was the late Ambassador Roy Señeres, my friend. And he ran for president, but he died. And he's a Bisaya also from Caraga region. Pinatay siya. Pinatay pagkatapos because of the intervention of Roy Señeres na pardon to si Sara. Na pardon kasi nagbayad ang Philippine government of blood money. Blood money is given to the family of the victim and the family will execute forgiveness and she was spared and she came home and she is now in Mindanao. She is Sara Balabagan. And because of that, the government passed another law which is Republic Act 10022. If 8042 was the floor contemplation law, this is the Sara Balabagan law. Which number 1, when you arrange, halimbawa ba, Director, ngayon nga, ma-apply kong trabaho sa Saudi Arabia, sir, niya. Ngayon may yung agency, magbayad ka ng 80,000 placement fee. Kan buang ni mga agency nga, mudawat sa speakers, mudawat sila sa OFW, mudawat sa dito sa employer. Kami may employer. You find me a very good Filipina maid and I will pay you $5,000. $5,000? US dollar, 5,000 sa isang maid, ibayad doon sa agency. Kanya, ang applicant, pangayuan sa nilang pera, so both sides, no? So mayong applicant, Director, I have no money, I'm very poor. Mayroon na yan. You go to the next room, there is a lending company. Siya rin pala may-ari ng lending company. Kita mo? So, kung hindi man siya may-ari, meron siyang share. Papipirmahin siya doon na ang salary niya for the whole year will be remitted to the bank account of the lending company. That is another violation. That is a prohibited act, and that is a criminal offense. Are you listening to me, ladies and gentlemen?
Yes,
Attorney.
Yes, attorney.
Are you learning from me? Are you learning?
Yes.
Number 8, number 5. Mayon nga, pila man day interest anang mo mag-loan ka para ibayad sa placement fee. Nya mo charge sila og 10% every month. No, that is too much. What is allowed is 8% the whole year per annum, compounded annually. So anything higher than that is a prohibited act. Kita mo yan? EU is SEER. EU is SEER. Pwede yung USA SEER. Pwede yan, baliktarin mo. No? Suspended ka na, tapos nagre-recruit ka pa. Suspended ka ng agency, nagre-recruit ka pa. Tapos, number 7, yung insurance na sinabi ko kanina, pinabayaran sa OFW. That's prohibited act. Number 8, yung medical exam ba? Halimbawa, director, mayroon na ikaw, dili na ako ma-process ang papel nimo, wala kay medical certificate, wala kay hepatitis, wala kay PTB, wala kang HIV, lahat na yan, kunin mo, pati COVID, lagay mo dyan. Sir, meron na akong kamag-anak na doktor, pwede itong medical certificate, matag itong kamag-anak. No, hindi pwede. Kailangan yung clinic niyan, the same floor. Siya rin pala tag-iya sa clinic, no? That is another, yung bang number 8 dyan, exclusive compulsory arrangement to undergo health examination, nga dili sila mudawat og medical certificate coming from other clinics. That is not allowed by law. Doon kayo ni mga job applicant. Kaning number 9 pa, yung bang mag-PDOS. Do you know what is the meaning of PDOS? Pre-departure orientation seminar. All Filipinos wanting to go abroad must undergo training or orientation. Halimbawa, ikaw, gusto mong punta sa Dubai, bigyan ka ng lecture. Ano bang batas ng Dubai? Anong kultura ng Dubai? Paano mo sabihin ng thank you? Paano mong sabihin ng sorry? Ano ang dapat hindi mo gawin? Kaming mga babae, huwag kayong maligo na magpakita kayo ng basa na buhok. Kasi ang basa na buhok ay invitation to sex. Ngayon, kaya ma-rape yung mga Pilipina, mahilig maligo, magpakita ng basa na buhok. Nandoon yan sa PDOS, Pre-Departure Orientation Seminar. Dinagdagan ko pa nga yan nung labor attaché ko. Pagdating pa doon, may PAOS pa. Ako lang gumawa dyan. Ano ba yung PAOS? Post-Arrival Orientation Seminar. Kung ikaw nakalimutan mo yung PDOS, huwag mong kalimutan yung PAOS. Kasi yan, ang sinabi dito sa number 9 na may mo training kong PDOS, sir. Naamang ko'y kaila, sir, nga naa sila service provider sa PDOS. Di may mo. Ari yun rin sa amo. Kaning mo, ari yun na. Di mi mo dawat uglaing certificate. That is another act that is prohibited by law. Panghuli, merong isang OFW nagbayad ng malaking placement fee. Pagdating doon, nakatrabaho lang o 1 month, nagkaroon ng gera, halimbawa Libya, na-repatriate. Pag-repatriate niyan, pag uli din dako mo nag-utang kay ni pirma mo na dito, naghatag pagaling post-dated check. Now, under the law, the agency is duty-bound to renegotiate the loan. In other words, ikaw agency, puntahan mo yung lending agency, i-renegotiate mo yung loan. Kasi hindi niya napakinabangan at bayad siya ng malaking halaga, hindi naman siya nakatanggap kasi nagira eh. No? Kahit ba ang gira is out of your control, you have to help her. No? So, ganun ang mga, any question? Do you have any question?
No,
sir.
Bigyan ko kayo na examination. Number 1, explain the legal principle justifying the applicability of Philippine labor laws to employment contracts signed by OFWs working outside the Philippine territory. Answer. The principle is lex lute contractus. Since the employment contracts are perfected in the Philippines and signed, attested by the POA, the law of the Philippines shall apply. This is a protection to labor so that our OFW will not be subjected to unfair situations where it is the law of the employer that will apply, not the law of the OFW. So here, in the case of Samer versus Cabiles, so how do you answer this? Ang according to the Supreme Court, in the case of Samer versus Cabiles, ngayon sir, pag makalimutan ng mga title ng kaso, basta kung makalimutan yung title ng kaso, na lang na well settled is the principle in our jurisdiction that as decided by the Supreme Court in a long string of cases, magayon yung kama palagi. So, state nyo ang principle. Do not state any principle without a basis, without an according. Because the word according will spell the difference whether you will pass the bar or not. Yung word na according. Or bago-baguhin naman yun, hindi pareho, puro na lang according. Sabi mo, in accordance with, or pursuant to, or in line with, as decided by the Supreme Court. Ganon na. As explicitly provided in the Labor Code, ma-impress ka na ang examiner, basta that is the way you answer. Believe me. So it is that principle that assures protection to labor even if they are abroad. Kasi yung constitutional provision, the state shall afford full protection to labor, local or overseas. So how does the state protect labor when they are overseas? Through the internationally accepted principle of lex lute contractus. Number 2, question. Okay, basa nga niyan, Mr. Carion. Basahin mo. Mr. Carion.
Yes, sir. If an OFW signed a document in Dubai waiving his right to security of tenure and authorizing his foreign employer to terminate his employment at the latter's option, even without cause, is he under estoppel? Thus, could not file a case of illegal dismissal anymore?
Ayan. Answer.
Answer. No.
Sige, basahin mo. Answer.
Answer, no. OFWs are not under estoppel, even if they signed a waiver of their right to security of tenure. Letter A.
Sabihin mo, under Article 1306 of the New Civil Code. Ganon. Tapos basahin mo yan. Basahin mo yan. Invalid surrender. Sige. Tuloy mo.
According to Article 1306 of the Civil Code of the Philippines, invalid surrender of a constitutional right to security of tenure is nullified
by the Supreme Court.
By the Supreme Court.
Sige, tuloy mo.
In which, while our Constitution recognizes that parties may stipulate in their contracts such terms and conditions as they may deem convenient, these terms must not be contrary to law, morals, good customs, public order, or policy.
Kita mo? Kita mo, ma-reconcile mo yung labor code at saka civil code? Oh. Maayon ni mo basa si Karyon, maabogado gini. Pila edad ni mo, Karyon?
33 na, attorney.
Ika na mga Karyon, judge man gina. Judge Karyon, bata pa ko, naagoy judge. Numeriano Karyon. Napoy batanong kayong tagarunda na judge dito sa Argao. Karyon yapon to. Daghang Karyon nga judge.
Yes,
Katong professor sa UB, si Attorney Karyon, Ernesto.
Under ko na ni attorney.
Bugadong to sa kuan, sa ALO. Na arbiter man to. Si Erning. Taga Barili daw to si Erning. Buhay pa ba si Erning?
Buhay pa man to, attorney.
Buhi pa, attorney.
Kaning niwang, di gid mamatay dayon. Ano yung mga tambok may unang kamatay? No?
Yag, attorney.
Sige, tuloy mo yan, Attorney Karyon.
Okay. Number 2. OFWs are not under estoppel even if they signed a waiver of their right to security of tenure. Reason is the waiver is contrary to law. It's letter A. Letter B. The above cited clause is contrary to law because, as discussed, our Constitution guarantees that employees, local or overseas, are entitled to security of tenure. And letter C, to allow employees to reserve a right to terminate employment without cause is violative of the guarantee of security of tenure.
Okay, alam nyo ito another technique. Ang ibigay ko sa inyong teknik ha. Gumawa kayo ng answer sa bar, lagyan nyo ng letter A, letter B, letter C. Huwag kayong gumawa ng sobrang habang paragraph na masyadong dikit-dikit yung mga sentence. Wala man lang nag-leave ng one line. Mainis ma-examiner yan. Kasi mga tigulang na unang examiner niya, yung lisod-lisoron pagbasa. So, you make it easy for them. So, lagyan nyo ng letter A, letter B, ano ba? Imo bang kono ba? Imo bang putol-putulon mga answer ni mga punto-punto pareha ko gabuhat kag sumari ba? Do you see what I'm trying to tell you?
Yes, attorney.
Ito, what is the legal implications of recruitment without passing through POAA? Is such arrangement allowed by law? Ito, mali lang itong pagkagawa sa PowerPoint. The answer is no. Because under the labor code, as provided by the labor code, the processing of the document must pass through the POA. That is in Article 18 of the Labor Code of the Philippines. No? There is a ban on direct hiring. So if you surf the website and you have a chat with an employer, and the employer promises to employ you, and you say, you fly to Dubai, and when you arrive here, we will sign a contract. That is direct hiring, and that is banned by the Supreme Court. And what is the reason? The reason is protection to labor. If you do not have an agency here in the Philippines, and you are victimized by your employer abroad, our POAA, our labor arbiters cannot acquire jurisdiction over the person of your employer. We cannot have a case because we can never have jurisdiction over them. But if they have an agency here, the agency will answer for all the acts or the omission of the principal, which is the employer in the foreign country. Do you understand what I'm saying? Can you see what I see?
Yes, attorney.
Ay, tawag na, abogada mo na. The POAA as the instrument of the state in the protection of OFWs. Pero pag sinabi ng the state shall afford full protection to labor, ang dami niyan. Who will protect? POAA, DOLE, labor attaché, ambassador. These are all instrumentalities of the state. And what are their functions? To protect labor. What is the reason for protection? Social justice. And what is the means to achieve social justice? Police power. O, kita mo yan. Palagi ulit-ulit yan eh. How does the Supreme Court apply the principle of the Equal Protection Clause for OFWs in a case questioning the limitation of back wages to only 3 months? You listen to this, ladies and gentlemen. What I will tell you is very important because the ponente here is Marbek Leonen. Marbek Leonen is the examiner. Alam mo, lahat ng question dadaan sa examiner, pwede niyang baguhin, pwede niyang i-reject. Powerful ang chairman. The chairman is the most powerful because if the examiner will make a question, that question is subject to the approval of the chairman. Nga ito si Marbek Leonen, magaling na professor ito. Hindi ito naging judge sa RTC, hindi ito dumaan sa hierarchy, dumiretso to Supreme Court. Favorite ito ni Noynoy Aquino eh. Si Presidente Noynoy, madali siyang ma-impress sa mga akademisya na mga bright. Namo si Serrano, diretso Supreme Court, di na-impeach kasi masyadong junior tapos ginawang Supreme Court. Mabuti si Leonen kasi tahimik lang siya. Mamatay na lahat ng mga justices, buhay pa si Leonen kasi he is the youngest. So itong kaso ganito, maminaw mo ha. I'll tell you the story. And when you hear the story, you will remember the principle. When the Labor Code was promulgated in 1974, the provision of the code is very clear. All victims of illegal recruitment or illegal dismissal, I should say, illegal dismissal, is entitled to, for the Philippine base, is reinstatement with full back wages. Pero pag OFW, walang reinstatement. It's only the payment of the unexpired portion. So if you are deployed to Kuwait, you have a 24 months contract, 2 years. After 4 months, you were illegally dismissed. You should be entitled to 20 months. All the unexpired portion should be given to you. Okay? Ngayon, nung pinas yung 8042 na floor contemplation, batas ni floor contemplation, yung Magna Carta for OFW. Ito ha, napaka-ironical ito. This law is supposed to help the OFWs. Ito mga congressman, mga baldito, nag-insert sila ng isang provision nga wala yun na hisguti sa mga committee hearing, sa plenary, wag yun hisguti. Muna gitawag og secret insertion. Na ano man na-insert mo sila? Ang mga agency nag-produce og million kanabang ihatag na to sa mga congressman nga gitawag og lobby money. Lobby money na kana intang balaod, sir, ayuha intang dili mi mapahama kay kanang balaod nga magbayad mi og unexpired portion. Pait kay may mga recruiter, sir. Ano? Wa ma mi control og kanang among gi-deploy dito og i-dismiss dito sa mga Arabo na kami din magbayad. Wa ma mi control. Well, those are occupational hazard, but the law says you should pay. Ngayon, in order to avoid unjust enrichment, kolektahin mo yung binayad mo, ikaw agency, you collect that from the principal. Are you following me? Director, are you still here? Umalis na director, ano? Attorney, umalis na director.
Morning lakaw na, attorney.
Nag-violate siya sa balao ni Kinso. Balao ni Kinso, you should not go out of the classroom. Ibalik kay may meeting sila ni
Naa sila meeting, attorney.
Ma'am Liling. Okay. Nakatuhog mo sa akong gisulti nyo so far? Nga,
Yes, attorney.
Kanang mga
Yes, attorney.
agency kanang tanan nga agency mao bitaw na nga go insist gintang dunay agency. Kaya ang agency gyud mo tubag. Bisag mo ingon pa na sila, sir, di man na sala na mo, sir, kay dili man kami ga-dismiss. Dili lagi kamo ga-dismiss. Pero you are bound by the acts of the principal. You are an agent. So, you collect from your principal, but you have to pay. Kaya meron kang meron kang nakadeposito sa bangko na 5 million eh. Yan ang panagot na escrow amount eh, para pag may mabiktima kunin dyan eh. So, ganun ang nangyari. So, gi-insert nila sa 8042 pagkaso ng Gallant, yung unang kaso Gallant versus Serrano, kana si Justice Austria Martinez. Martinez Austria or Austria Martinez, isang babaeng justice. Siya ang sumulat noon. Siya ang sa in-bank decision. In-bank yun eh. Because it's a constitutional issue. Because that provision was inserted. And so pagdating sa Supreme Court, the issue is that provision constitutional? Why? Because it violates the Equal Protection Clause. Why? Because kung ikaw Pilipina ka, naakas Pilipinas, na biktima ka legal dismissal, bayaran ka fallback wages. Pero nga naman mga OFWs na subject man sa discrimination, now nga naman gilimit man sa 3 months, kay gi-insert man na sa mga congressman nga ang limitasyon 3 months ra gyud bayaran. Gi-insert ba kay nilakad na yan sa mga congressman. So sa madalit sabi ni Justice Austria and unanimous decision ng lahat ng 15 justices, that provision is null and void. And so Antonio Serrano then was given the fallback wages. Ngayon, di talo na ang Kongreso, na-annul na yung ginawa nila. Gumawa na naman tayo ng batas, yung Sara Balabagan Law, which is 10022, in-insert na naman nila uli. Tingnan mo yung mga congressman natin ha. Alam mo yung mga congressman natin, mga buutan kayo nagtanaaw ninyo, pero dagko kayo ng mga kwarta. Kaya nga no, pila ka milyon ko itong nag-produce sa tanang mga recruiter, ipanghatag dito, basta mubuto kag yes. Daadyo kayo madawat. Anya, gi-insert man daw. Ikaduha na yung unang insertion na annul. Karon gabuhat na sa bagong amendment, gi-insert gyapon. Ditong kaso ni Joy Cabiles, ito na ngayong pangalawang annulment. So parang rainbow doctrine ito eh. Gagawa ng kalokohan ng Kongreso, i-annul ng Supreme Court. Tapos gagawa na naman, i-annul ng Supreme Court. So the last bastion of protection to labor is the Supreme Court. Kung walang Supreme Court, luoy kayo ng mga OFW. Sinulat ko yan sa column ko sa Freeman eh. About 3 years ago. Yung mga recruiter na gusto nilang itago ng desisyon na kay may balo na gani ang mga OFW mo file din nagkaso. Unya makadawat din nagdakong amount. No? Are you following me? No, ito. Pakibasa nga yan, Miss Elisa Medes. Miss Elisa Medes.
Facts. Joy Cabiles was recruited and deployed to Taiwan for a 2-year contract. She was illegally dismissed without just or authorized cause and was denied due process. After only 3 months of working abroad, she filed a case of illegal dismissal. The labor arbiter decided against the OFW, but the NLRC and the CE ruled in her favor.
So, pumunta sa Supreme Court si Kwan, yung Samir. No? ito yung mga desisyon. Pakibasa lang. Pakibasa lang yung Supreme Court in Bank, Leonen. No? Sige, pakibasa lang, Elisa. Her security of tenure was violated.
Okay, sir. Her security of tenure was violated. Number 2, the employer failed to prove just cause. Number 3, the employer deprived her of due process. And number 4, the law limiting back wages to 3 months is unconstitutional. Violates the Equal Protection Clause.
Yan ang mga kuan nyo. Ang punto de vista nyo sa answer nyo. Lagyan nyo ng letter A. No? This case should be decided in favor of the OFW, Joy Cabeles. Letter A, her right to security of tenure was violated because the employer failed to prove justice and she was deprived of due process. Letter B, that law that was used to limit her back wages to only 3 months is unconstitutional. As decided by the Supreme Court in the case of Samir Overseas Contract versus Cabeles, that law, that portion of the law that limits the back wages to 3 months is unconstitutional because it violates the Equal Protection Clause. Kita mo, pagka ganun ang mga answer ninyo, no? So, pakibasa, tuloy-tuloy mo na, Elisa, para ka naubos ng boses ko eh. Total, bata ka pa.
Tesa ka, USEC, yung maglisod kong baso ko ay glass.
Batanon ba bitaw ka? Sige, ano
Number 5.
No, sige.
The principal abroad and the recruitment agency here, both liable. They were declared jointly and severally liable for the salaries of the unexpired portion of the contract. Number 6, the OFW must be paid legal interest based on the en banc decision in Gallery Frames versus Nakar.
Alam nyo, ladies and gentlemen, every time you come across with a case of illegal dismissal and there is back wages, you always award 6% interest because that is the en banc decision in the case of Dario Nakar versus Gallery Frames, which was penned by Diosdado Peralta, who is now the incumbent Chief Justice of the Supreme Court. By the way, he is our neighbor. He is our neighbor here in BF Homes, Parañaque. I have 2 neighbors, 2 Supreme Court justices. One is Justice Diosdado Peralta and the other is Justice Lucas Bersamin. The daughter of Chief Justice Lucas Bersamin was my student, Pia Bersamin, who is now a judge in the Regional Trial Court of Las Piñas. The husband of Pia was also my student. They were classmates. Nagligawan sila. Pareho silang judge. Yung husband, kay husband naman siya. Di man siya anak ni Chief Justice. City Court lang siya. Pero yung wife, yung babae, kay anak man, RTC judge. Yun ang maganda. Kaya kayo, mag-judge kayo para daghan naman ta kayo being judge. No? Ito, pakibasa nga ito. Kinsay sugo na ito diha. Madali-dali na ito sugo. Mauli naman yung uban. No? Si Jesus Bordalba, nandyan pala si Attorney Gullias. Nakita ko pa rin si Attorney Gullias. Kakugiyana ni Attorney Gullias. No? Batanon pa manggod. No? O ikaw, Attorney Bordalba, pakibasa lang yan.
Okay, Attorney. The social legislation for OFWs covers them overseas. Let's look the contractual supply. Quoting Justice Isagani Cruz in Ramon Pareto versus NLRC, this court is not unaware of the many abuses suffered by our overseas workers in the foreign lands where they have ventured, usually with heavy hearts, in pursuit of a more fulfilling future. Breach of contract maltreatment, rape, insufficient nourishment, subhuman lodging, insult, and other forms of debasement are only few of the inhumane acts to which they are subjected by their foreign employers, who probably feel they can do as they please in their own country.
Tuloy mo kay doon na pa na ikuan. Doon na pa na continuation. Yan. Ito, while these workers,
while these workers may indeed have relatively little defense against exploitation while they are abroad, that disadvantage must not continue to burden them when they return to their own territory to voice their muted complaints. There is no reason why, in their very own land, the protection of our laws cannot be extended to them in full measure for the redress of their grievances.
You know, Mr. Bordalba, why Justice Isagani Cruz wrote this? Because he was exasperated because the POAA, the NLRC, and even the Court of Appeals decided against the complainant Ramon Pareto. And the reason for the decision against the OFW were procedural matters and technical matters. And therefore, the Supreme Court, speaking through Justice Isagani Cruz, expressed the outrage of the highest court of the land at the propensity of some of our arbiters, commissioners of the NLRC to use technicalities to defeat the demands of the workers which are justifiable. Remember that under the labor law, technical rules are not binding. All doubt shall be resolved in favor of labor. And the state is mandated to afford protection to labor, local or overseas, organized or unorganized, and shall assure labor, shall guarantee, the word is guarantee, labor, the rights to, enumerate na kagad, the right to, living wage, just humane conditions of work. Memorize Article 13, Section 3. So this is the case that I mentioned earlier, which is the precedent. The precedent in the case of Joy Cabiles is the case of Antonio Serrano. By the way, it is already 8 o'clock, no? And our time is up. I want to ask you, did you learn something tonight?
Yes, attorney.
Yes, attorney.
A lot, attorney.
Wa ba mo magmahay? Wa ba mo magmahay nga nitambong mo kanining maong lecture?
Wala, attorney. Mapasalamat.
Wala gyud, attorney.
Mapasalamaton ninong attorney. Thank you kaayo.
Asa ko mo magmahay nga libre niya kinasing-kasing pag yung pagserbi ninyo niya tagsara mo makakita og tao nga imbes matulog magpahuway na kay tigulang nagugo unya mo serbi hinuon ninyo mga batan-on mo na nga ug na gani mo mapulutan nga grasya o mutya mahala gina ninyo kay moabot yung panahon kami ni Attorney Wagas. Ihap na mo, ani kaabot na 10, anak abot 20, mawadaan sa mig gana bang mag-serve. Muna nga, mayong daghang maminaw kay dili masayang ang atong panahon. Di ba?
Yes, attorney.
Dr.
Yes,
Iwagas,
Yes,
unsa man,
yes, attorney.
tapos na ang inyong semester o
Mana, attorney.
umana
Mana
man di
mo
ay?
ang semester. Yes.
O ngayon katong mga porcher mo attend yung appeal dinhi kay aron mga kuan, makapulot sila unsa man kapahuway pa sila. Kano sa
Ay,
man mo
naay
sugod ang
fourth year
sunod?
diri uban, attorney.
O kano sa man mo sugod ang semester?
By
Sunod.
August, attorney.
August ato pa na bakante nga July.
Yes.
Sa kabuan lang bakasyon niya kami doon naman may summer gatudlo po ko og social legislation anya June ra gyud og July duha ra ka bulan June og July niya umano na namong balaod na tana SSS, PhilHealth, Pag-ibig, tanan ng mga balaod na ng PWD, mga LGBT, mga tanang mga tao nga nasa laylayan ng lipunan, pati yung mga indigenous, pati yung mga agrarian reform, lahat na yan. Tapos namin, mabilis kami, twice a week Twice a week ang lecture. So, kamo wala mo'y summer.
Attorney. Wala, attorney.
Sige, pahuway lang ka. Ikaw layway pahuway. So,
Pagkuhan sa attorney. Picture.
magpicture ta, magpicture.
Yes, attorney.
Eh, 20 city na lang ka mo.
Palihog ko,
Rambling man.
turn on sa inyong camera, please.
Naka na mga naong ninyo nga kuan kayo,
Mga quarantine look.
mga lockdown look. Ayaw mo pagpangit-ngit. Na may kidlat kabaliro. Kinsa man as kidlat kabaliro. Ikso na sa dawog-dog. Katawar ba siya? Pag-ampo in taon mo dahil nga di mo makuan, madutlan na mga virus. Ay,